Move to the final aspect for today, which is a further civil society presentation by Ms. Nonhlanhla Khumalo from SAHA, the South African History Archive, and she will be giving us an indication of the importance of transparency and access to information in respect of state capture, as well as indeed the prosecution of apartheid-era crimes. Thank you, Ms. Khumalo.
I greet you all. As she already mentioned, my name is Nonhlanhla Khumalo, representing the South African History Archive. We thank you for the invite, and we are really grateful to be invited to contribute to the People's Tribunal, and we are happy to support. Just to give a brief background about who is SAHA, the South African History Archive was established in 1988. It is a human rights archive committed to documenting and promoting awareness of historical and contemporary struggles for justice. Our organization positions the notions of accessible archive records as central components of human rights, governance, culture, discourse, and practice, particularly in relation to recovery of truth. We also promote awareness, and we test the parameters of South Africa's access to information legislation, the PIA. SAHA ensures its archive is available to communities that will normally not have access to those materials. In 2001, SAHA established its Freedom of Information program called FOIP, which has since then been at the forefront of the efforts to test the parameters of PIA. Through FOIP, we assist individuals, activists, the communities, other NGOs and researchers with submission of PIA requests. Up to date, we have submitted over 2,000 PIA requests to a range of public and private bodies. And these requests related to records for present day and apartheid-era corruption. For today, I will speak about 4 key things: the role of secrecy, the role of transparency, our experiences, and our recommendations. I had provided the notes for our panel. I'm not sure if you received them. So secrecy is an issue because it enables corruption. As most of you may know, that the apartheid-era government bred secrecy. It mandated secrecy quite often within the operations of its government. It did not only do so to its government, but it also caused the state-resistant movements to operate in secret too. Therefore, it created a culture of secrecy in South Africa as a whole, and this culture sustains corruption. As we may know that on one hand, when secrecy is flourishing, on the other hand, corruption is being sustained. We thus submit that we really need people in our communities who will work hard to unveil secrecy and root out corruption in South Africa. In South Africa, we have tools that can assist us, or that assist us to combat corruption. We have the Constitution. We also have PIA that gives effect to Section 32 of the Constitution. However, these tools are not effectively implemented. I'll explain this when I get to our experiences. The role of transparency. Transparency is an antidote to corruption. It is well recognized nationally and internationally as a tool, as a significant tool to combat corruption. South Africa committed itself in several international legal instruments to combat corruption by ensuring the mechanisms are in place that will guarantee access to information that could assist to fight against corruption. It is, for example, it is a signatory to African Union Convention on resisting and combating corruption. It therefore has a duty to deter corruption. And for that reason, we as South Africans should have access to information that will enable us to hold to account those who are in power, those who abuse power for personal gain. Also, our Constitution guarantees transparency. It provides in Section 32 that everyone has the right to access to information, that is, any information held by the state or held by any person, and any information that is required for the exercise of any other rights. As I mentioned earlier, that PAIA was enacted to give effect to Section 32. However, the mechanism for access to records, record creation and record keeping, and proactive disclosure duties in sector-specific laws are not always complied with. For example, the Financial Intelligence Center Act of 2001 provides, among other things, it requires records of business relationships and business transactions to be created and kept for at least 5 years from the date in which a transaction is concluded or from a date in which a transaction is terminated. And then the Consumer Protection Act of 2008 is also requiring, among other things, the recording of agreements between suppliers and consumers. The Electronic Communications and Transaction Act of 2002 is also requiring permission of collection of personal information to be recorded and kept for indefinite period of time. However, it's not always, these duties are not always complied with. This shows from our experiences that the record creation and record keeping duties are given less priority, and there is less awareness of duties, of these duties. This is evidence from the request that we made to public organizations, public bodies. Some of the information officers will be like, they really comply with their duties. Even their responses, they really show that they are not aware of what are they obliged to do. There is also less incentives for compliance, insofar as there are no severe consequences for not complying with statutory obligations. In our experiences, we have used PAIA for close to 18 years. Given corruption relates to abuse of power for undue gain, and given it often happens in relationships between state and private parties or private entities, my focus today will be our experiences in using power to test transparency on those relationships, that is on public-private partnerships. Just to give a brief definition of what is public-private partnerships, it is defined as, they are essentially commercial transactions between state and private parties, in terms of which the private party performs state functions or acquires use of state resources for commercial private use and receives a benefit by compensation either from the state or by charging users a service fee or both. SAHA have requested for information from both PPPs and non-PPPs presented as PPPs. So these non-PPPs presented as PPPs, usually relationship held, they're being held up as PPPs, but they're not complying with the law. We have submitted about 49 requests to public-private partnerships for records relating to them. Out of 49 requests that we submitted, 63%, just to note, on the notes that I provided, there is a correction on, okay. So 63% of those requests were not responded within the statutory time frame provided in PAIA. Some of them, 15 of them, we received substantive decisions after the request was deemed to be refused. But however, we had not taken the matter further. And then 16 of them, there were no substantive decision at all. So these were deemed refused by operation of law. So in terms of PAYA, when a request is deemed refused by operation of law, it bears the same consequences as active refusal. Then we are entitled to lodge an internal appeal, of which we did with those requests. I would like to highlight that 63% is a high rate. And this tells us that the culture of secrecy is still pervasive in our country. There is still a lot of work to do in order to move to a culture of transparency. 22.5% of our requests were actively refused, of which they relied on Section 23, which says access is denied on the basis that either records cannot be found or they do not exist at all, or they do not exist. So this section requires that the requestee must provide us with an affidavit or affirmation stating all the measures or steps taken to locate the records and even the people who assisted in searching for the records, of which in most of the cases, it's not always where they comply with that section. We rarely get an affidavit. We get an email saying the records do not exist. And then we request them to comply with Section 23. We don't get that from some of the public bodies. It's not always where we say, provide a Section 23, and then they do that. So this also shows that there is still secrecy. Maybe they're saying the record does not exist. We don't trust them because they don't want to give it under oath. So it shows that some people, some members of public bodies, they still think they are above the law. They don't want to comply. Also, the 22.5% of actively refused, also it's a high rate too. It shows that the reliance to Section 2023 tells us of the failure to comply with the duties of record creation and also the duty of keeping records, important records of important decisions and transactions, or the failure to keep records in a safe and accessible manner. 33% of our 49 requests that we made were met with the decision to grant access in full or in part, of which 8% of our requests were treated as non-compliant. The first one, it was a transfer, which was treated as non-compliant because the requestee did not acknowledge that the transfer was invalid. The other three private entities denied that Section 8 applied. They argued that they were private bodies by definition, therefore Section 8 of PAYA did not apply to them. Section 8 provides that if a private body by definition but performs a public function or exercises a public power, such a body is treated as a public body for requests relating to that function or that power. But despite of us citing the section explaining what Section 8 really says, they refuse to comply. And this denial really shows that the application of Section 8, the denial of the application of Section 8 also shows that the culture of secrecy remains prevalent in South Africa. In our recommendations, SAHA submits that to ensure that transparency is implemented in business relationships between the state and private persons or entities, the means of access to information must be improved. And we recommend that the following measures must be employed. That information on steps being taken to ensure these relationships become more transparent must be published on a regular basis. The gaps in sector-specific legislation that should contain record creation and record-keeping duties, and possibly also proactive disclosure duties. Because most of the instances, people have to use PIA in order to gain access to information, which should be disclosed to them proactively. Those records should be identified and addressed. The public must be given a fair and equal opportunity to analyze government projects prior to their implementation. And we think they need to be allowed to examine and review the related processes. For example, the tendering process, the selection of bidders, and the procurement procedures. We suggest that the public should be given an opportunity to review that before the project commences. We also recommend that the legislation with record creation and record keeping duties should include strict sanctions for non-compliance. And that efficient records management and compliance with requests and disclosure obligations should form part of the performance management targets of senior state executives. We also recommend that the information about service delivery and the related procedures, budget and expenditure should be made publicly available on the websites of government departments or institutions that are closely connected to that specific public function. In relation to PPP projects, disclosure of information on the National Treasury website by way of PPP quarterly reports. As some of you may be aware that it says they provide information on a quarterly basis. This is not always the case. Information, yes, it is provided, but it's not timely provided. So we recommend that such provision of disclosure of information must be timely and consistent in order to enable the public to have an insight into the projects and to give input on the further management and implementation of the projects. We feel that the public are being treated as good as receivers of services. But I think the public need to be given information. They are not only good as receivers of services, they can also make contribution on the provision of services. That's all. Thank you.
Here too. I mean, as you know, this tribunal and the hearings are focusing on the arms industry. And what we've heard here over the last few days is how this sector is known for secrecy. So in the applications using PIA, I just wanted to know whether you have done any in the arms and arms-related industry, or Armsco, Denel, have you done any of that?
No, not at all.
So nothing in the armaments industry? Okay. You okay?
Okay, then thank you. There are very few questions from us. That doesn't mean that your evidence and what you have said to us is not important. We are very conscious of the hard work you are doing and the importance of that work to the Constitution and to the reconstruction of our society. So thank you very much for taking the trouble to come along, and you are now excused. Thank you.